Disclaimer: the following is for educational, informational, and entertainment purposes only. It is not to replace the advice of an attorney, lawyer, or legal counsel. If you need the representation by any of the aforementioned, the viewer does so at their own discretion. All rights reserved without prejudice. UCC 1-308. The following links in the description are to sites related to unique consumer rights violations. This information may assist in the entry of complaints in regards to discrimination, conspiracy, and the dispute of consumer rights violations related to inaccurate credit reporting, unlawful collection practices, foreclosure proceedings, in an effort to exhaust all means of remedy and satisfaction prior to reaching undesired outcomes that benefit only one party. Take into consideration of what remedies are available through consumer rights advocacy and the options that are essential to protecting your rights as a consumer doing business in the state of Florida or any other state. Should you have any questions, investigate all options a few lawyers may suggest and consider speaking with an attorney who will do the job with zero cost to you and only to be paid if you win. Check out the affiliate links and become a more informed consumer. Happy searching. Best regards, the Model Trust Core team. Laws pertaining to discriminatory conspiracy. Brief summaries. Clicking on these links available also in the description bar. The first of which takes us to www.law.cornell.edu, a reputable site for information. Conspiracy, Title 18, United States Code of Law 241, Conspiracy Against Rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any rights or privilege secured to him by the Constitution or laws of the United States, or because of his having so exercised the same, or if two or more persons go in disguise on the highway or on the premises of another with intent to prevent or hinder his free exercise or enjoyment of any right or privilege so secured, they shall be fined under this title or imprisoned not more than 10 years or both, and if death results from the acts committed in violations of this section, or if such acts include kidnapping or an attempt to kidnap, aggravated sexual abuse or an attempt to commit aggravated sexual abuse, or an attempt to kill, they shall be fined under this title or imprisoned for any term of years or for life or both, or may be sentenced to death. More information to consider. The Fair Credit Reporting Act. Available on the ftc.gov site, FT standing for Federal Trade Commission. Protecting America's consumers. Let's do a search since it decided not to show us. FCRA, which stands for Fair Credit Reporting Act. We search Fair Credit Reporting Act. Guidance for business using consumer reports or credit reports to evaluate customers. Let's click on this link and see where it takes us. Featured, Fair Credit Reporting Act. The Fair Credit Reporting Act promotes the accuracy, fairness, and privacy of consumer information contained in the files of consumer reporting agencies. If your company meets the definition of a consumer reporting agency, if you furnish information to CRAs, consumer reporting agencies, or if you use that information for certain purposes, you may have obligations under the FCRA. Guidance for background checks. What employers need to know. Business must provide victims and law enforcement with transaction records relating to identity theft. So if you've ever suffered identity theft or you suspect yourself to be a victim or possible victim of identity theft, click on that link. Consumer reports. What information furnishers need to know. Consumer reports. What insurers need to know. Disposing of consumer report information. Rule tells how. Using consumer reports for credit decisions. What to know about adverse action and risk-based pricing notices. Using consumer reports. What employers need to know. Using consumer reports. What landlords need to know. what employment background screening companies need to know about the Fair Credit Reporting Act, and what tenant background screening companies need to know about the Fair Credit Reporting Act. All of these things and more available on the FTC website. Continuing on, we also have the FDCPA, the Fair Debt Collection Practices Act, which is available to us also on the Federal Trade Commission's website, as amended by Public Law 111-203, Title X, aka 10, Statute 124, Chapter 124, Statute 2092, in the year 2010. As a public service, the staff of the Federal Trade Commission has prepared the following complete text of the Fair Debt Collection Practices Act. Subsections 1692 through 1692, paragraphs. Please note that the format of the text differs in minor ways from the U.S. Code and what's U.S. Code annotated. So, depending on where you are, be aware and do be advised. All right. Legal actions available by debt collectors. But let's look at the table of contents. The short title: Congressional Findings and Declaration of Purpose. Definitions: if you are not literate or competent within the language that they use. Acquisition of location information. Communication in connection with debt collection. Harassment or abuse. False or misleading representation. Unfair practices, such as how people call you, and what time of the day they do decide to call you, and whom else they may contact regarding your debt, if you do have a debt that is yours. Validation of debts. How do you validate or verify a debt? Multiple debts, if such exist. Legal actions by debt collectors, what they may do and may not do. Furnishing certain deceptive forms, such as fraudulent or misconveyance of language. Civil liability. Administrative enforcement. Reports to Congress by the Bureau. Views of other federal agencies. Relation to state laws. Exemption for state regulation. Exemption for certain bad check enforcement programs, etc., etc., etc. Moving right along. More sites and information you should consider do pertain to RESPA, which stands for Real Estate Settlement Protection Act. Following the document takes us to a PDF, which gives us the Regulation 10 on just how to go about filing complaints and also what the laws and regulations are. Let's take a look at one of these sections, such as Section 6. Of the Real Estate Settlement Protection Act, which has a lot to do with 12 CFR, Consumer Financial Regulations, 12, Section 1024. You see short year statements, timely payments, list of home ownership, mortgage servicing, in which case often third parties pretending to be first party collection agencies or creditors are stating that they have rights to the promissory note and or mortgage note, but there is no exchange of goods or service or quid pro quo, this for that. All right. Error resolution procedures. Servicers must comply with error resolution procedures that are triggered when a borrower submits an error notice to the servicer. The requirements set forth in 12 CFR 1024.35 apply to any mortgage loan as that term is defined in 12 CFR 1024.31. The CFPB has issued an advisory opinion clarifying that because borrowers initiate the error resolution process, a servicer's communication with a borrower regarding an error notice are not subject to the cease communication provision of the Fair Debt Collection Practices Act unless the borrower specifically withdraws the request for an action regarding the error. The notice of error must be in writing and identify the borrower's name. Information allows the servicer to identify the borrower's account and the alleged error. So, ladies and gentlemen, go ahead and view that at your leisure, become a more informed consumer, and also consider purchasing some literature that may also assist you in filing complaints with the Attorney's General Office in the state of Florida, or whatever state you may be in, the U.S. Attorney General's complaint link, which also sends a copy of your complaint to the Federal Bureau of Investigation, the FBI, and also complaint links to the BBB, aka the Better Business Bureau. All right. And of course, in the event that you would like a little bit more information, a little bit more in depth, consider the purchase of this affiliate link that is also included in the description bar, the Consumer Financial Protection Bureau, CFPB, a legal analysis, which is available on Kindle for 99 cents. So, education does not cost very much. In fact, you should be doing yourself the service of getting this book. It's only 34 pages. It's page flip enabled. It's word-wise enabled, which means, if I'm not mistaken, it'll read to you. All right. And Title X of the Dodd-Frank Act is entitled the Consumer Financial Act of 2010, CFPB Act. The CFP Act establishes the Bureau of Consumer Financial Protection, or Bureau, with the Federal Reserve System, with rulemaking, enforcement, and supervisory powers over many consumer financial products and services, as well as the entities that sell them. All right. So this is your regulatory body who will enforce or protect the rights of consumers from fraudulent or deceptive or bad intending organizations to deprive the individuals who do business within the corporation's borders and boundaries of their income and or currency. So this is all about energy, and whatever it is that you invest your energy into is what you are interested in or motivated by. So either get interested in your rights or motivated in protecting yourself. Peace and love, education, uplifting the nation.